Hey there, in this video, I am going to be discussing the role of the criminal defense attorney. My name is Veronica. I am a criminal defense attorney here in California, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I am going to be talking about the role of the criminal defense attorney. And actually, I'm going to be talking about 5 key things that the criminal defense attorney is responsible for. So let's start with number 1. Number 1 is that we need to present our clients in the most favorable light. And this happens at multiple stages of the proceedings. So before court, if we're contacting the DA trying to get the charges dropped, we want to present the client through a letter, through their letters of recommendation, whatever that they have that we're submitting. We want to present them in the most favorable light, show the good things about them. We know that the police report will show the bad things. If the prosecution ever tries to get the bail increase, we want to talk to the judge and show the judge, here are the good things about my client. Here are the ties to the community. We want to explain all of this to the judge. If the prosecution ever asks for a restraining order and the alleged victim is, for example, my client's like wife or girlfriend, very frequent, I want to present actually both of them in their relationship in the most positive light that I possibly can so that the judge sees that and can use that and take that into consideration. Sometimes I'm talking to a DA supervisor when I don't like the offer that a DA has given me for my client on a case. And again, I'm presenting all of the good things about my client at sentencing, at jury trial. This is something that throughout the process, every single time we appear in court, this is something that I always want to do. And not every attorney does this, but it is part of our job. Some attorneys will say, oh, my client is late. I'm like, oh no, like he must be stuck in traffic. Or, I mean, not that I would ever do this or admit doing this, but hey, I told him to wait outside and here I am. Meanwhile, texting him. But overall, our job is to try to make you look as good as we possibly can because there is an entire other side, the prosecution, that is trying to make you look as bad as possible. Or if we're trying to talk to the prosecution before a court, the police department that is trying to make you look as bad as possible. And we want to make you look good. That is our job. Number 2 is evaluate the evidence that the prosecution or the cops actually have. See what we can attack legally. So for example, maybe there was an illegal search or you were in custody being interrogated and you weren't read your rights. Well, in that case, we probably want to file a motion to throw out either the confession, the whatever was found during the illegal search, whatever it may be, which will then cause the entire case, in most cases, not all, but many cases, to be dismissed. Number 3, and this is actually a really big one. I'm not sure why I made it number 3. I should have made it number 1 or 5 because it is incredibly important. And I do not believe that any public defender's office, no offense to them, but I don't believe that they do it well, not any that I'm acquainted with at least, keep you informed and make sure that you have all of the information necessary to make decisions. I mean, so in a criminal case, one of the most important things that you as a defendant are going to need to do is at some point in almost every case, you're going to have to decide, do I want to accept this offer or keep fighting, knowing that I may never get this offer again. It may actually get worse. And this isn't for every case, and if it gets dropped before a court or we're just trying to get it dropped before a court, you don't need to make any decisions. But if the case gets filed, then this is going to be the number 1 thing that you are going to have to decide. And you have to have all of the information, obviously. Like if you say, no, I don't want the deal, what is the worst that can happen, right? What are the chances? And I mean, we're not allowed to ever give percentage chances per the state bar, nor should we. But like, how strongly does your attorney feel about the case at trial? There are no guarantees, but like, hey, do we think that we have a chance? Do we think we're dead in the water? That information is really important, of course, for you to make a reasoned decision as to whether or not to accept a deal. So this is one that, I will say that the public defender's office, because in general, they are not communicating with their clients between court, right? They're too busy. Every day, every attorney there is at court and they're very, very busy. And at court, they have limited time to speak with them. Most of the time, they don't don't have time to advise their clients of this. So the clients really don't know what their options are. And this is something that is really, really important for the criminal defense attorney. Like, let's say that I look at all the evidence and I'm just like, I'm sorry, you are fucked. You are just totally screwed. I cannot, like, the evidence is incredibly strong. There's nothing I can do. Wouldn't you want to know that? Even if you don't like that. And that's not an assessment I often give my clients, but wouldn't that be important information for you to know if there's a plea offer on the table for you? You need to have that information. So your attorney needs to really look at the evidence and then give you an assessment of it so that you can make a reasoned, reasonable, informed, educated decision. Number 4 is, I don't know that all attorneys would agree with me, but I think being persistent is really, really big. And I'll tell you about a case I had. So it was a schizophrenic guy. Before this, he was totally mentally sound, apparently, like outwardly, living at home with his parents, going to college, playing video games, whatever. Normal dude who's like 20 years old. Suddenly he left. He just disappeared. Became homeless. Schizophrenia had just manifested itself in him. And his parents didn't find him until months later when he attacked an elderly woman, beat her to the ground, was stomping on her. Passerby had to like grab him and restrain him. And, you know, I hear about all this. His family bonded him out of jail. They brought him home. They gave him medication. They gave him, you know, all the treatment that he needed. He saw a psychiatrist very, very frequently until he became stable. And then once per week, he was finally okay. And at first, and actually not at first, for a very long time, for close to a year, the DA's office refused to give him any kind of treatment. They wanted him to go to prison. And I knew this kid, he has no criminal history. He only acted like this because of his mental health issues. And they didn't want to give him mental health diversion. The judge didn't want to give that to him either. And the DA's office was just persistent. Like, no, we want him to go to prison. 5 years in prison. Imagine this guy. The mental health treatment in prison is not good. So instead of where he was, and when I saw him, he was okay. He's with his dad. He's medicated. He's fine. He's stable. Going to the horror that is prison. What is he going to be like when he comes out? Obviously, that is not the right thing for him. That is totally wrong. That doesn't make any sense. But even the DA's supervisor, which is usually like the last line you have to get a good offer, said no. And I was just persistent. And I just kept emailing the DA's supervisor. I kept talking to the DA. I kept talking to the judge, just telling them, like, we're not giving up. We're not accepting 5 years in prison. We don't want to go, of course, we don't want to go to trial. We could plead not guilty by reason of insanity, sure. But then he's going to go to a mental institution. He is good at home. He's actually fine. If you disrupt him, if you pluck him from that environment, who knows what he's going to be like? But this is someone who, I mean, he's with his dad all the time. He and his dad were just like together constantly. And by the way, it's been years since this happened and there has been nothing. He hasn't done anything wrong. Like nothing bad has happened at all. Ultimately, I was able to get him probation with, you know, he has to do his mental health treatment as he was already doing. But that's been, I think that was like 3 years ago. Nothing bad has happened. Obviously, that was the right thing. That was the right thing for society. 3 years, he would have been out of prison by now and he would be, who knows what he would be doing. When you get let out of prison, they don't always even tell like your next of kin or your parents or whatever when you're getting out. So what, he's going to be wandering unmedicated, like all messed up, like traumatized. I mean, it would be horrific for society. I think that there would be at least one more horrible crime that would occur. And I've gone on a bit of a tangent here, but being persistent got me the right result. Like refusing to give in, and it doesn't work in every single case. That was just one that I was like, I know someone will eventually see what I know, which is that this guy should not be in prison. And I was right. And I'm not saying that if I have a client who is accused of murder that I can go ahead and just be like, no, I know it's right that you let him out. And you know, that's not the case every single time. But with some cases, being persistent is absolutely the key. I will say that almost every time, the very first offer you get is not going to be the last offer you get. Some courthouses are somewhat notorious for it. They'll give you an offer at arraignment, like your first court date, and make it seem like if you don't accept this, like you're just going to prison for a long time, you're getting the max or like whatever. But it's not true. It will usually be better. They're just trying to get rid of cases as much as they can so they don't have like as many on the docket. Number 5 is when we do have a hearing, like a motion to suppress, and we have the cop on the stand, when we have a preliminary hearing and we have either cops or witnesses on the stand at trial, is cross-examine and counterattack. You know, point out the weaknesses with them, point out their problems. obviously we are the defense in this criminal justice system. We are literally on the defense, right? We're trying to guard against all of this stuff that is being thrown at us, but we need to go in the counterattack too. I'm not saying in every single case, but that's only because there can always be an exception to almost every rule. Because in every case that I can think of, I mean, yeah, we need to go in the counterattack. We need to go hard on cross-examination. A big thing that I love to do, especially in like murder trials, attempted murder trials, we have detectives on the stand, detectives sitting next to the DA during trial, is talk about all the things that they didn't fucking do. Because many times I'm trying to swear less on this channel because I think that may be a thing with YouTube and the algorithm, or I don't know, I don't want to get banned. But that is a big thing, that many times they just jump to the conclusion that it's like my client and they haven't done enough research, or they've never tested things for like items of evidence, gone even for fingerprints, or tested my client for gunpowder residue. This is a really, really big thing. This is a big point. And honestly, for the most part, most detectives, most police agencies that I have ever encountered are not doing any of the shit that you would think on CSI, or the things that you would think, like if I think, ooh, if I were to, don't we all do this? Ooh, if I were to plan the perfect murder, here's what I'd be careful of, or whatever. Honestly, like most of that stuff, they never even check. They never even do. I mean, sadly enough, at least in LA. So I like bringing all of that up. And if it's a victim who is going on the stand saying, oh, it's very sad, I'm a victim, this is what happened, I want to bring up all of the inconsistencies in that person's statement. And sometimes, like, you know, if they're telling the truth, there may not be that many, but most of the time there are going to be at least some embellishments, some inconsistencies, something there, and your lawyer has to use that. So it's not a matter, really, as a criminal defense lawyer, of just being nice and being able to be like, hey, my client is a really nice guy, please give him a second chance. Like, you need that. That is important, yes. And that sometimes is enough to very early on get the case dismissed. But you have to know the law so you can evaluate everything. You need to be willing to talk to your client, inform them of what's going on, answer their questions, make sure that they can make reasoned, sound decisions, and if necessary, you need to be ready to go to trial and go as hard as you can on the other side to give your client the best possible chance of an acquittal. Anyway, I hope that this answered your questions as to what the role of a criminal defense attorney is. If you do have a case in California, feel free to give me a call. You can find my number down below, or you can book a consultation with me there.